Hello, everyone. My name is Bradley Kramer. I'm coming to you from Beverly Hills, California, where I practice law. My practice focuses on medical malpractice cases, personal injury cases, and business litigation cases. Today, I wanted to just create an informal video to discuss something called MICRA, which is the Medical Injury Compensation Reform Act, which was put into place first in 1975. There's a lot of controversy surrounding that law. There has been since the time it was enacted, and specifically there's some controversy surrounding it today because a number of organizations, including organizations that represent the plaintiffs' attorneys, consumer attorneys, are putting forth a movement to increase the cap that is set forth by MICRA. So let's talk just for a second about what that cap is. Under MICRA, since 1975, there's been a cap on damages in medical malpractice cases. That cap is set at $250,000, which covers all what's called non-economic damages for a medical malpractice victim. Non-economic damages means essentially anything that can't be quantified economically, meaning pain and suffering, or any of the related topics that go along with that. What that means is that if a physician or a nurse or hospital or pharmacy kills somebody and they don't have a loss of earnings that go with that death, for example, the maximum amount that that individual or his or her family can recover is $250,000. The same applies for a baby that is killed or lost as a result of malpractice. The maximum compensation under those circumstances is $250,000 for cutting off the wrong arm or wrong leg, or misreading a cancer, for example, on an x-ray that leads to an individual's death. The maximum allowable damages for recovery to that family is $250,000. Now, that $250,000 was put into effect in 1975. It has never been adjusted for inflation or for any other reason since that time. If you look at that $250,000 in today's dollars, it comes out to the equivalent of about $50,000. So in terms of today's dollars, someone who is compensated for, let's for example say the loss of an arm or death of a family member, is compensated in the equivalent dollars of $50,000. In today's money. There's a bunch of controversy and a bunch of upheaval from doctors' communities and in the insurance business who claim that increasing the cap on damages is going to lead to catastrophic results. And in fact, the insurance company has already stated that they are willing to put $50 million into a campaign so that the cap cannot be raised. And I wanted to address just a couple of the issues, a couple of the misleading statements that the insurance companies are going to put forth to try and convince people not to raise the cap. The first is that if you increase the damage caps, there are going to be more frivolous lawsuits filed. There has never been any information ever in any state to suggest that increasing damages caps will increase the amount of lawsuits or frivolous lawsuits against doctors. In fact, when you file a medical malpractice case, the amount of money and time that goes into those cases is astronomical. Those cases can cost over $100,000. I would say that a minimum amount of expenditure for any medical malpractice case that I'm involved in is $15,000. So the concept that attorneys are going to jump on board to start litigating frivolous medical malpractice cases when it costs that much money to litigate them is entirely misleading. The other associated concept with that is that medical malpractice cases take an enormous amount of time and effort into litigating them. Medical malpractice cases are notorious for not being settled, for going all the way to trial. By the time you get to trial in a medical malpractice case, an attorney is looking at anywhere between 200 and 500 hours of time put into that case. So for the insurance companies or physicians to somehow believe that attorneys are just going to start filing lawsuits left and right because of the increased cap is absolutely absurd. When attorneys file medical malpractice cases, they're incentivized over cases that have merit. And I, for example, am not going to put money into a case that doesn't have merit just because the possibility of a higher recovery at the end of the day is higher. Because in medical malpractice cases, the chance of me getting that type of recovery is minimal to begin with, because they're litigated so aggressively and defended so aggressively. But in a case that doesn't have merit, the chance of recovering any money, much less more money, if the cap is changed, is simply not true. The other issue that insurance companies rely on is the fact that doctors will leave California if the damage caps are increased. Well, that's entirely misleading as well, because the medical malpractice premiums have not increased substantially as a result of anything dealing with lawsuits being filed or not filed since 1975. Furthermore, all of the money that comes from filing medical malpractice cases generally comes from insurance companies. It doesn't come out of the doctor's pocket, which leads me to a third point that insurance companies make, which is that filing increased a number of medical malpractice cases is going to ruin doctors' careers, and that's absolutely untrue. When a lawsuit is filed, it's that lawsuit, if it has merit, is going to be filed whether the cap is $250,000 or $1 million. Like I said before, all of the money that comes out of settling these cases or from a verdict is almost universally from insurance companies. So that point is also a bit misleading. The other point that insurance companies usually rely on is that it's going to increase the possibility that doctors practice defensive medicine, and that in and of itself will increase the cost of healthcare in this country. That's misleading as well, because whether or not the cap is $250,000 or $1 million, if a doctor is going to be sued, a doctor is going to be sued. A good medical malpractice case is going to be taken by an attorney, and likewise a bad medical malpractice case is not generally going to be taken by any attorney, because most attorneys don't want to put in the time, effort, and cost associated with litigating those cases. So a bad case is still a bad case, and a good case is still a good case. It's been 38 years since the MICRA law was put into effect, and it's never been changed. It's never been adjusted for the cost of inflation. So what winds up happening is you have victims of medical malpractice being shortchanged significantly with regard to how much they're able to recover for that family member who may need care for the rest of his or her life, who may not be able to do anything that he or she used to do. It's a really unfortunate circumstance, and the law really hasn't been updated to reflect today's society. It would be the equivalent of putting a law into effect or keeping a law in effect that said that it had to do with men. All men are created equal, and not incorporating women into that law. It's the same level of ineptitude that keeps that law in effect. So we really do need to change this law. I encourage you to put your pen to paper and write to your congressman. If there's a ballot put in front of you to raise the cap, I encourage you to sign it and change the law for the better. Thank you.